Well, although it seems very surreal, we actually have made it through half of the year 2020. And if we have to find the keyword to summarize this half year, and of course the keyword would be COVID-19. And COVID-19 is more than just a hygiene crisis, but also present challenges on many other aspects, and of course legal is one of them. And today in our webinar, I will talk about some very common labor and contract issues from the legal perspective under the background of COVID-19. And first of all, I would like to take a few minutes to introduce to you our law firm. And Wang, Jing law firm is a law firm based in Guangzhou with more than 100 lawyers. And we have the core practice in commercial litigation, dispute resolution, real estate, corporate, banking, finance, and many other expertise. And myself come from foreign related department, and we offer our legal assistance to foreign individuals and foreign corporates and also their subsidiaries in China. And our team has professionals who can speak English, Spanish, Italian, and French. About myself, I practice in trademark, labor dispute, commercial dispute, corporate compliance, and foreign direct investment. And I can work in Chinese, English, and Spanish. Our webinar will be consist of two main sections, and the first one is about labor issues. And in this section, I will talk about three very basic and very commonly seen legal instruments that could be used by the companies during the COVID-19, which is the economic layoff, rotation of work and salary reduction, and the cease of production. And in addition, I will talk very briefly about some preferential policy from the government, two of which are the social security reduction or exemption, and some subsidies from the labor part. We all know that at the end of January, since the lockdown of Wuhan, the whole China is basically is basically under lockdown too. And then the State Council extended the Spring Festival to the 3rd of February. And later in Guangdong province, the government issued official notice that sectors or companies who are not working in the essential sectors shall not resume their production until February 10th. So this is a great challenge. It's a big blow on many of the companies in China. And of course, many companies under this situation will think, how can I save some costs? Can I maybe reduce some of the labor costs? Then very normally the first thing that many companies will think about would be the economic layoff. And yes, it's an instrument that's provided by the labor contract law. But there are some requirements. First of all, this economic layoff should be used only by companies who is facing severe economic distress. Now at this point, you might wonder, but what's the definition of severe economic distress? How bad my situation should be in order to apply this legal instrument? Is a big drop in the revenue due to the COVID-19 considered as severe economic distress? If you are having these kind of questions, it's very legit because I have the same question too. The thing is, the labor law itself does not specify or does not define very clearly what's severe economic distress. Although in my research of the previous cases in Guangdong province, most of the time during the court hearing, the judge will consider the company going through severe economic distress if the company can submit a balance sheet that can prove the deficit for at least 2 years in the past, and or they can submit a third party audit report with the conclusion that the company is going through severe economic distress. So before you apply this legal instrument to actually perform the economic layoff, please check if you meet this requirement, if the company is really going through severe economic distress. That's point number one. Second, there is a threshold uh, amount of the employee to be terminated under economic layoff. So it should be more than 20 or more than 10% of the whole staff. The reason behind this requirement is to avoid the company using the name of economic layoff, but to actually terminate some or single employees. So remember, if the amount of employees that you want to terminate or the company wants to terminate is no more than 20 or is less than 10% of the whole staff, then economic layoff may not be the right legal instrument in your case. Thirdly, there is a required 30-day prior announcement to the labor union if the company has a labor union, or if not, to the whole staff, and to listen to their opinion. The thing about this is that this announcement or this meeting is not to get their consent, but need to notify them about this economic layoff plan of the company and to record, to listen their opinion in this regard. And after this whole staff meeting or the meeting with the labor union regarding the announcement of the economic layoff, the company should also report to the local labor bureau about the layoff plan. So normally in this stage, the labor bureau will require the company to submit some supporting documents, for example, the layoff plan, like how many employees that you would like to terminate, what's the reason behind that, like what's the balance sheet of your company, or what's the economic situation that you are facing that actually force the company to take this economic layoff, so this kind of documents. And one fun fact, one interesting point is that although the law does not specify the Labor Bureau as the final judging authority of whether a company can go through economic layoff plan, in this stage, the Labor Bureau will issue a document, sort of like approval for the economic layoff plan. Now, this approval, we can consider it as the preliminary examination from an authority to see if this company actually meets the requirement of the economic layoff. And of course, if after the company submission of documents, the Labor Bureau finds out that actually you don't meet this requirement to do this, like for example, the employees that you would like to terminate is not more than 20 or is less than 10% of the whole staff, or the documents that you present to them from the bureau side, they see it, they do not deem it as severe economic distress, then at this stage, they may just give you the rejection of the economic layoff. And this could be a final checking from the authority before the company can before the company actually goes through the economic layoff. So this step is quite important for the company to see if they really meet the requirement of the economic layoff. And then the last step, will be paid the severance to the employees. Under the PRC labor contract law, for employees terminated under economic layoff, they deserve a severance from the company calculated as 1 month salary per each year they work in the company. Another point that worth mentioning is that within 6 months after the economic layoff, if the company recovers a bit from the operation and would like to recruit new employees, the company should give priority to the former employees terminated during the economic layoff from the same position. So that's something the company should keep in mind. If within the 6 months after the layoffs, situation changes, it gets better, and would like to hire new people for the position from which they terminated the employees, they should give priority to the former employees. But one thing we should also keep in mind is that under the COVID-19 situation, the employees who cannot provide work due to the COVID-19 medical treatment or due to medical observation, or they are under mandatory quarantine by the government, or cannot provide work due to other emergent measures as a control against the virus. For them, companies cannot apply the economic layoff on them. And at the same time, if their labor contract expires during this time, the contract will be extended till the aforementioned situation ends. So this is especially important for companies who had the foreign employees who are now trapped in their mother countries and cannot come back to China, because we all know that China now has the border closed and foreigners cannot just come back to China. So for the employees, the foreign employees who are in their countries, like for example in Spain, they cannot come back to China to work. But under this situation, economic layoff cannot be applied on them. And if their contract expires during this time, it will be extended until the aforementioned situation ends. So that's something we should keep in mind. We are talking about foreign employees who are trapped in their own countries and cannot come back. And since economic layoff cannot be applied on them, so as companies, what can they do to reduce the cost for these employees? Because they are like in foreign countries, they are not actually working for the company. Is there a way to reduce the cost? Here we comes to this point. Yes, there is. Company could consider rotation of work and the salary cut. What's rotation of work? It means that instead of applying the standard working schedule, 8 hours per day, 5 days per week, upon negotiation between the parties, company can offer a rotation of work, meaning to cut the work schedule. So maybe instead of 8 hours per day, just 4 hours, or maybe instead of 5 days per week, just 3 days or even less. And subsequently, there is the salary cut because the work provided is reduced. So how to do it? First of all, rotation of work and salary cut should be negotiated with the employees, and it cannot be applied unless they agree on it. The reason of that is because the rotation of work and the salary cut, they are major changes of the labor contract. So it has to be consented by both parties. So first of all, as company, you need to negotiate with the employees. And after they agree to the rotation of work, the new work schedule and the salary cut, we as lawyers strongly suggest a company to sign a written agreement with the employee to put in black and white the new working schedule, the salary cut, the duration for the rotation of work, and other key terms as the supplementary agreement to the labor contract. So in this way, parties can be better protected under the terms of this supplementary agreement. And what this agreement should be, what kind of terms and conditions you should have, well, this is the time that you should come to consult me and find a professional opinion on that. As we just mentioned, that rotation of work and salary cut should be done with the consent of the employee. So it's based on the negotiation between the parties. So what if employees do not want to agree to the rotation of work? What if they simply don't want to have the salary cut? And as company, what can they do to reduce the cost if there is basically no work to be done in the company due to the COVID-19 situation? So at this time, what company could consider is the cease of production. Well, cease of production literally means to stop the operation of the company. And this is a decision that can be made unilaterally by the company. It means that contrary to the rotation of work that should be achieved upon the negotiation with the employee, the cease of production itself can be decided by the company without prior consent from the employees. And it should be applied to the whole company or at least the whole departments, because literally cease of production means the operation stop, right? So it should be the stop of operation of the whole company, or at least some departments who are affected by the COVID-19 situation or are the objective situation that stop them from being in operation. We have a case that's not during COVID-19, but we have a client in Foshan. It's a manufacturing company, and because they failed the environmental test, the water that they emitted contains some pollution that exceeded the standard of the local government, and then they received a fine from the Environmental Bureau requiring them to stop the production. So under these circumstances, they had no other way to do but to stop the whole department of the production. But then, of course, the sales department, the purchase department, other department can work just fine, but just not the production because they need to figure out the emission of the pollution, right? So during all this time, the cease of production was performed on this single department of the factory, which is the production department. And then it's justified by the law, of course, because they are under some objective circumstances. And the reason for the cease of production to be applied to the whole company or at least whole department is to avoid that the company using this cease of production as an excuse to put a single individual or just some employees on hold. So in that case, putting one or two employees on hold, it should be done under rotation of work and cut off salary, which should be achieved upon a negotiation with the employees. It cannot be done as a unilateral decision as the cease of production. So that's the reason why the cease of production has to be applied to the whole factory instead of just single or some employees. And the third step of the cease of production should be sending the proper notice to the staff and notify the Labor Bureau. And this step, more than from legal perspective, it's actually more for maintaining a harmonized a relationship between the company and the employees, because of course during the cease of production, the employees don't have work and their salary will be reduced substantially, and no one will be happy. And under some circumstances, they may also go to the labor bureau to protest, even though the cease of production, if done properly, it's totally legal and the company shouldn't have any risks of that. But the employees will just be very emotional and they complain to the bureau, etc. So in order to maintain the harmony inside the company and also try to have the support from the local labor bureau, it's strongly recommended that the company should give a proper notice to the staff and notify the labor bureau with some time prior to the application of the cease of production. In the past, we have walked through this stage hand in hand with our clients in order to apply this cease of production, and we achieved quite satisfactory results. The fourth step of the cease of production is to figure out the salary payment. After the production is stopped, for the first month, all the employees shall be paid with full salary as the work they normally provide, even though during this month they don't have to do anything because it's the cease of production. And after the first month, for the employees that do not provide any work at all, the company should still pay them some living, or we can call it as the maintenance subsidy, which is no less than 80% of the local minimum salary. And even though during the cease of production, some companies may require some minimum, very basic, essential support from some staff. For example, maybe the accountant that need to come once or twice per month to calculate the subsidy that should be paid to the employees. Or maybe if you have a big warehouse and you need a doorman, a guard, to check whether the warehouse is safe or whether the factory is safe, you need some minimum basic essential work. Then for those people who provide this, their salary should be negotiated between the company and the employee based on the amount of work that they provide. And of course, in this case, we also suggest to make a written agreement on that regarding the work provided and the salary during this cease of production, and make this agreement as the supplementary agreement of the labor contract. Besides the three legal instruments that we introduced that the company can take, from the government side, there is also some preferential policies that are supposed to support the companies during this time. Like, for example, there is the exemption and reduction of the Social Security, the pension, unemployment, and work-related injury, the three of them. The part contributed by the enterprise can be exempted or reducted, and this will be applied to the end of this year. And for companies to enjoy the exemption or the reduction of these three securities, three types of social securities, no additional application is required. So the companies can just log in the social security system and declare the employee's name and declare the premium as normal, and the system will automatically calculate the exemption or the reduction on your behalf. So it's quite simple and does not require additional effort or additional application for that. And we also have the deferral of payment of Social Security. The deferral means that if companies, even with the reduction of the three types of social securities, still facing problem of this reducted payment, then they can apply to delay the payment for, in principle, no more than 6 months. And during this delay of payment, no penalty will be applied. On the other side, there is also subsidies. Like, for example, for salary paid to the employees who received medical treatment or were under medical observation, there is the subsidy of no more than 50% of the pension premium of these employees. And this will be the subsidy to the companies. So the government will give you this amount of money as a reward or as the subsidy for the salary paid by the company to the employees who were not able to provide work due to the medical treatment. And there is also the refund of no more than 50% of the unemployment insurance premium actually paid last year for the enterprises whose termination rate is lower than 5.5% or no more than 20% of whole staff for enterprises with insured staff less than 30. Now, this subsidy is not special for COVID-19. Basically, every year, enterprises can apply for this refund as a reward for stabilizing the employment situation inside the company. So this is not something new. The third point is that there is this subsidy for new recruitment during COVID-19 for enterprises who produce and transport anti-pandemic material. So the subsidy can be up to 1,000 RMB for each new recruitment. Just now we talk about some labor issues during COVID-19, and another hot topic during months, because due to the COVID-19, the government has taken some measures so that can in fact impair the ability to perform the contract. So under this situation, many companies would wonder, is COVID-19 considered as force majeure? And if so, and we know that it is, how does the Chinese law regulate this part? So in this section, I will talk about the definition of force majeure under Chinese law and how exactly should company apply this legal instrument, and what are the key points that they should take care of. The general principle of civil law in China defines force majeure as any objective circumstances that is unforeseeable, inevitable, and insurmountable. And also where the non-performance of civil obligation is caused by force majeure, then no civil liability shall arise thereof, except otherwise provided by any other law. This is the definition under the general provision of civil law, but it's very broad and very general because it does not specify what exactly are the situations that can be deemed as force majeure. Although traditionally we have an idea that maybe natural disasters such as flood or earthquake and government action or social unrest can be seen as force majeure. So COVID-19 as a disease, can we see that, does the Chinese law recognize it as force majeure? So on February 10th, 2020, during the press conference held by the Legislation Commission of the Standing Committee of China, we have a clear answer on that. And yes, COVID-19 is force majeure because as a public hygiene emergency, it has led to corresponding government epidemic controlling measures, and parties who cannot perform the contract thereof, they are facing the impact of COVID-19, and this COVID-19 situation
Sorry, please wait a minute. There are some problem in the computer of Eloisa.
very sorry for the incidents that I just have. Turned out that my computer was running out of battery. Unfortunately, I have the charger on my hand, and I just needed some time to connect it. And very sorry for the incident. And now I'm back. I hope everyone is seeing clearly still my PPT and myself. Everything okay, Erica? Perfect. I'm very sorry. Let's continue the PPT. So we were saying that on the press conference on February 10th, 2020, the Legislation Commission of the Standing Committee officially declared that COVID-19 is force majeure. So having that as background, what are the key elements to actually enact a force majeure shield for companies or parties that are affected by COVID-19? First of all, we should know that it's not fundamental to have the force majeure clause in the contract to enact this resort. Why is that? Because under the Chinese legal system, force majeure is a legal instrument default by the law. So parties do not need to have a very well written or have a very clear force majeure clause in the contract in order to use this resort. So check your contract. If you don't have the force majeure clause inside the contract, don't be panicked because that's default by the law. Second, you need to check how much is the impairment of the ability to perform the contract is caused by the force majeure event, because during the hearing or during the litigation procedure, if this case ends up in the court, the judge will clearly gauge how much the COVID-19 situation has affected the party from being able to perform the contract. I'll give you a very simple example. If like COVID-19 happens after a party delay their delivery or delay their performance, then under these circumstances, of course, the party cannot use force majeure as as a legal ground for their defense, because their delay of performance happens before the force majeure, and of course the ability to perform the contract is not affected by this. So second, a very important factor is that in order to enact a force majeure, you should prove, or the party should prove, how much their ability is actually affected by this force majeure event. And third important point is that it requires the party affected to send immediate notification to the counterpart and to take all possible measures to the party's capacity in order to mitigate the loss. Like, for example, if as a Chinese supplier, after COVID-19 situation happens and their factories is shut down, does not have the enough workforce to actually produce the order that they received before, then under these circumstances, the affected party, like in this case, the factory, should send the notice to the counterpart immediately, explain everything about the COVID-19 situation, like, for example, what's the government measures, why are they not able to resume the production, why they don't have enough workforce for that, and also find out a plan with the counterpart to see if there is any way to mitigate the loss. Say, for example, if there's a way that we can agree on a new delivery day without intriguing the penalty, or actually to modify the clauses stipulated in the original contract. So based on this, we give some very practical suggestions for the parties who wants to use this force majeure shield. First of all, the parties or the company should seek for professional legal advice, of course. In this case, a professional legal practitioner or lawyers can give you a more thorough analysis of the cases that you are in, to actually understand if the party in this case is actually affected by force majeure and how much they are affected by them. And of course, if the notification was sent in time, and if not, how to mitigate that, and how to initiate a negotiation with the counterpart in order to mitigate the loss, or in order to reach to a better term, or to modify the original contract. So under these circumstances, professional legal opinion is essential. Second part is to check the contract signature date. As I mentioned before, if force majeure, or in this case COVID-19, happened before the contract signature date, means that when the parties sign the contract, they are already well aware of COVID-19, and they are well aware of the force majeure, and they still commit to the terms and conditions on the contract, then they need to assume the relevant responsibility. So if at the signature date of the contract, COVID-19 has already happened, you are already under this situation, and you still want to commit to those terms, then under these circumstances, you cannot use force majeure, because in the definition, we know that the force majeure is something invisible, you cannot predict it. So if you already know it, then it's not unpredictable. That's the logic behind it. The third point is to check if you have a force majeure clause in your contract. But you might wonder, but you just say that it's not essential to have a clause in your contract to use force majeure. Yes, of course, that's right. But if you have a force majeure clause in your contract, then you should abide by what's written there. For example, if in your force majeure clause, it's clearly stipulated the time within which you should send the notification to the counterpart, or the kind of document that you should send to them. For example, if on the contract it says it requires a notarized document to prove the force majeure event, then you need to comply with the term. So you need to check if you have a force majeure clause and do exactly what's written there. Fourth step would be send notification to the counterpart immediately, and you should support this notification with the relevant official government notice or some force majeure certificate. I think most of you have already seen or have already heard about the force majeure certificate issued by CCPIT. This is a kind of certificate that certifies the objective fact of COVID-19 itself. But what this certificate does not certify is how much the party's ability to perform the contract is affected by COVID-19. So with the CCPIT force majeure certificate, we can show the counterpart that COVID-19 actually happened in China and what is the government measures taken due to this emergency. The fifth point will be keep track of the evidence on how the situation impair your ability to perform the contract. As we explained before, if the case ends up in the court, the judge will see, okay, it's COVID-19, it's force majeure, but how much your ability to perform the contract is affected by them. So at this point, you need to submit the proof. For example, in Guangdong province, companies that do not work in the essential sectors shall not resume production before February 10th. Then if you as a factory whose ability to perform a contract is affected by this official government notice in Guangdong province, then at this point you should present to the judge this government official notice forbidding the resume of production before February 10th. And this is the evidence that you should provide, among many other things. And the sixth point would be to start a negotiation with the counterpart to find out measures that both parties agree to mitigate the loss. At the end of the day, a failure to perform the contract will create the loss on both parties that nobody would like to have. And I believe that most parties, even though there is the legal instruments there, and we could go to the legal resort, we could solve the case in the court, but that's not the most efficient way to solve the problem. And me as a lawyer, I don't believe it's the best solution for a contract dispute, especially for the companies, in this case, going to the court for lawsuit. They need to bear extra costs, the lawyer's fee, the court fee, and also spend some time in the case, like first instance, second instance. So it will be a cost in time and economic perspective. So if it's possible, start negotiation with the counterpart and reach a new agreement that both parties can accept, and a plan that can mitigate the loss. It would be the best scenario. And of course, legal advice and suggestion along the negotiation process is also essential. And that's the end of my webinar, and thank you very much for your attention.